pleased to have online for a discussion Ali Sabri, Bhavani Fonseca, Hermisa Tiga, and Salia Pires. My name is Priyanka Hektiarachi, and I'm the country representative of the Westminster Foundation for Democracy. We are a UK-based independent public body working to strengthen democracy in different countries. In Sri Lanka, we collaborate with institutions such as Parliament, political parties, civil society organizations. We work with parliamentarians from the different political parties. We work with parliamentary officials, community representatives, and the like. The Westminster Foundation for Democracy has been conducting a series of stakeholder consultations on the subject of COVID-19, its impacts, inequalities, and then the solutions. Today's discussion will focus on and examine legal issues that have surfaced, the use and availability of law, the misuse and unavailability of law, and this can range from a range of issues such as those you see in a private law context, such as tenancy, domestic issues, right through to public law issues involving citizen and state, curfew, and so on. And that's very much in the hands of each of the speakers on their reflection. In terms of format, each of our speakers will speak and reflect for about up to 10 minutes, and then there'll be 2 or 3 minutes for a second round, should they wish to clarify, expand, or respond to some of the points that have been raised during this discussion. And we're hoping to conclude within the hour. So may I invite our first speaker, Ali Sabri. Ali, welcome, and may I ask you to introduce yourself and begin your reflection, please.
Good afternoon. I'm Ali Sabri, a lawyer by profession. Thank you, Priyanka, for this initiative, and I welcome all my other colleagues at the bar. Actually, it's a very timely, important discussion. As far as I'm concerned, these are extraordinary times, and extraordinary times require extraordinary results and measures to come out, not only for Sri Lanka, for any country in the world. So in that sense, it's important that first, we have our priorities right. The priority number one is to contain this pandemic, because we know in Sri Lanka we have limited beds, limited number of hospitals, limited number of support which the healthcare authorities could provide to our people. So we need to understand that. So if it go out of hand and escalate, that could lead into a calamity. So priority number one is to see that we manage this pandemic and fight to contain it. If somebody says that it could be eradicated, I think that's not practical within next 18 to 24 months, at least until we find a vaccine to it. So the most conservative kind of assessment says that it is 18 to 24 months away. So that's priority number one. Priority number two, while that happens, how do we ensure the law and order of the country as well as the essential service are not disturbed and not perturbed? That's second priority. The third priority is how we slowly get back to the near normal or the new normal that we are all talking about to get the economy going. Because if we just allow this to happen and only focus on containing COVID, our economy would have collapsed, and there would be more bigger challenges we have to face. So we have to have that set up in mind in try to find a solution to that. So that has been, I think, that has been the way it has been approached by the government. That is why I think, first of all, we must congratulate everybody involved in this, the healthcare workers, the leadership which are being given, the army, the intelligence, and the public health authorities. They have done a fantastic job compared to many other countries in the world. So if, for example, if we are talking so much high of the efforts of New Zealand, for example, New Zealand have done a fantastic job, but they just have 5 million people. They have a massive country. There are no slums, but still they have 1,500 cases, 21 deaths, and still about 150 under treatment. So compared to that, Sri Lanka with 22 million of people, with more than 100,000 shanties in Colombo alone, we have managed so far, after 8 weeks after the real escalation, which is on the 11th of March, where we found the first patient. We have 8 weeks have come. We have managed to keep it about 900 patients with 9 deaths. So having said so, going forward, now coming back to our most important thing, how do we face with the legal facilities and the challenges that we have? There are a range of facility challenges we have. First of all, rather than bringing in new laws, at least how do we implement the laws which are in place? That's most important. I think, first of all, we must find a way out to get the courts to function immediately. That's very, very important. For that, so many people have innovated. We have seen that. That innovation should come into place. If necessary, I feel some of those, for example, I saw a very good set of proposal with the Colombo Law Society as well as the Bar Association has provided, including sometime suspending the rules in order to facilitate the justice in this kind of situation and have those hearings going. So I think I'm happy that the Supreme Court started functioning from Monday, and other courts have slowly coming through. So in that kind of situation, I think if we can't even have physical hearing, for example, we need to look at it innovatively and have hearing through what we are doing now, webinars and discussions like this, or even cross-examinations what we could do if necessary, or submissions could be done to Zoom, this platform, and so many other things. I remember in Sri Lanka in 2008, I remember Salia would probably remember, for the first time in the commercial high court, we had a cross-examination of a foreign witness in USA through video conferencing. But that's it. Since then, it has just died down. So I think we must make use of this as an opportunity to find how we can get the things going. So in that, how to embrace technology, how to get e-filing, proceedings to be given through email, or dates to be matched through email, and so many things could be done. And I know some of our lawyers are working very hard to see that preventing the detainees or accused from coming to courts, because by any chance when he comes and God forbid if he get infected with COVID and he go back to the to magazine or somewhere, and there are thousands of prisoners, and our prison status is not that great. We all know that. So in order to prevent that, they were saying whether we should introduce video conference in there, so physical presence of the accused is not necessary, and he can meet them or participate via the kind of Zoom or anything of this sort. So I think now, for me, its most important thing is to first to see how we get the court system back on track, implement it, and see that it's smoothly functioning. Number one. In order to do that, technical support or other things, but is within our power, we should immediately do that. Then, having said so, I'm also aware that so many other countries, there are other challenges, tenancy, and then contract, frustration of contracts, tenancies, and these are a number of areas we need to look into. I am aware that the presently or currently the Law Commission is looking at some of those areas and see whether it could be done. And I am also aware some other countries like Singapore and all already had come out with those some of those laws. So we need to probably look into all these things and approach in a systematic manner while keeping our priorities in place. That is to see that we combat this pandemic. We see that the essential services are not disrupted. We see that the rule of law and the public security is ensured. We see that normalcy returns slowly, and whatever the way, the legal structure which could support that process, it should be done. So that's the parameters on which I'm seeing on this, and probably going forward, I'm sure there can be specific suggestion from my other colleagues from the bar, and we all can discuss that. That is how I see this.
Thank you, Ali. Bhavani, may I ask you to introduce yourself and then to share with us some of your reflections, please.
Thank you, Priyanka. My name is Bhavani Fonseca. I am a senior researcher and an attorney at law. First of all, thank you for hosting this discussion. It's a very timely topic in terms of what we are facing at the moment. And as the first speaker said, we are in unprecedented times. I don't think Sri Lanka has ever had this kind of challenges, and it's a global pandemic, but it's very much a local context that we are looking at. Now, in terms of the pandemic and the challenges, the crisis that has arisen, I think we need to look at it in terms of what are the key challenges in terms of democracy in Sri Lanka. And I understand there are several cases now before the courts. As the first speaker said, courts did open on Monday. So I think I'm going to stay away from matters that are before the Supreme Court. But that said, I think it's very important to remember that when we talk about the legal issues, we're looking at what is democracy. How does democracy work in times of a pandemic? And for that, you need the three arms of government. That's the executive, the legislature, and the judiciary. Now, we first found out that Sri Lanka had cases about 2 months ago, and since then the cases have been increasing. And till Monday, we didn't have the Supreme Court functioning. And we don't have a parliament functioning. So we only had the executive arm in charge, making decisions. And I would say in terms of the cases, the response, the work done by the frontline defenders, that is the health professionals, those who have been in the front lines have been extraordinary. I mean, we wouldn't be having this conversation if there were major mess-ups. So we need to recognize that. But that said, the worrying thing is, and the point made that we need to look at the existing laws, I totally agree. I think Sri Lanka has laws that can address certain situations. Now, for example, we have the Disaster Management Act, which provides for disasters, which provides for a council. So you have structures provided in existing laws. So definitely, we need to use what is there, which is relevant to the present context, but also keeping in mind that for government to work, you need to have the three arms of government working. So even with the Disaster Management Act, you have a role for the executive, but you also have a role for Parliament, because Parliament needs to be kept informed of decisions that are being made. So you see that even existing laws, including, for example, the PSO, which provides for the emergency, which provides for curfew, I'll talk about that issue, has a specific role where the executive arm has to keep Parliament informed. So there is a checks and balances that's provided within the existing legal framework. So that's very important to keep in mind. The Constitution, the legislative framework we have recognizes the roles the three arms play. And you can't have one arm just taking decisions without involving the other two. So that's a very fundamental question. The other one I think we need to be a broad principle is to have certainty in terms of decisions made, and that those decisions are based on legal framework, that those are not ad hoc, that it doesn't lead to arbitrary, unjust practices. And that's very important. So you need to have the law that people can look to, which provides the certainty. So 3 arms of government, checks and balances, certainty of law to ensure that any action taken is proportionate, is legal, and is non-discriminatory. So I think if you look at it from that aspect, in terms of what's being done, while there are some positives in terms of addressing the cases, there are also concerns in terms of the legal framework. I'm not an expert in the health area or commenting on the testing, so those are not things that we should be looking, or at least I can't comment on. But in terms of the legal framework, I think there are a couple of issues I'd like to talk, depending on how the time goes. But one issue that is very much discussed and debated is the whole premise of this lockdown. And what is the legal basis for the lockdown? Now, before we go into that, I want to be very clear. We need measures to be taken to ensure that there is social distancing, that people are protected in times of a pandemic, that the movements do not need to be the way it's being done. There has to be, of course, restrictions. But the Constitution also provides, in terms of those restrictions, certain safeguards. You can't arbitrarily just have restrictions imposed because someone decides that's the way it goes. So there is very specific Constitution provisions, Constitution safeguards, clarity in terms of how, for example, freedom of movement can be restricted. And in that, I think it's very important because people are talking about various concepts of curfew, from quarantine curfew, which frankly, I am yet to see in the legal framework where that comes from. But curfew is provided under the PSO, the Public Security Ordinance. There are 2 ways of bringing curfew. One is through the emergency regulations, and one is through Section 16 of the PSO. So it's clearly provided. The president can introduce curfew. But that also provides a very important check in terms of imposing curfew. It says that within a specific time period, that curfew needs to be, the gazette needs to go to Parliament, and it's only valid for a month unless Parliament renews it. So the law actually provides for it. So we need to understand that there is a law. The whole point of let's use existing laws, completely agree. The law provides for that. So there is specific provisions by the law in terms of process, the procedure, and in terms of the parameters of that. What seems to be the case is that the police are issuing public notices. We also see the media office of the Presidential Secretariat issuing notices, but there's nothing in terms of providing what that curfew is based on in terms of the legal framework. So there is a question, and these questions need to be asked. It's not saying we shouldn't have the curfew, it's asking on what basis the curfew is imposed. So I think these questions need to be asked in terms of, fine, we need these measures, the law provides for these measures, but how is it being done? And let's also remember that the judiciary has provided for, in terms of respecting fundamental rights, clearly articulated when restrictions can be imposed. There is a Supreme Court jurisprudence on this. So any violation of that is highly questionable, and this is where we stand. So when one talks about the Quarantine and Prevention Diseases Audience providing, I asked the question, where in this, what are the regulations that provide for this? Because the Constitution clearly states otherwise. So that's my first point in terms of clarity, in terms of accountability, in terms of transparency. At this time, we need to answer those questions. Connected to this matter is the whole issue of freedom of expression. So, you know, one should have the right to critique, question. But in April, I believe it was the 1st of April, the police issued a notice which says that anyone who criticizes public officials will have to deal with, will face strict legal action, something to that effect. Now, that raises the question that is connected to my first matter is, why cannot we question? Why cannot we critique? Critiquing, questioning should not be seen as preventing someone from doing their work. For a democracy, for a functioning democracy, freedom of expression, freedom of speech is extremely important. That's provided by the Supreme Court in several cases. So, you know, and there are laws where you can take action, where if there is fake news, if there is incitement, if there is misrepresentation. But a blanket statement to say you cannot critique is extremely, extremely worrying, and goes to the heart of, is it proportionate? Is it necessary? So I think that also needs to be kept in mind in terms of raising questions. Finally, I know I have, I think 2 or 3 minutes. I want to raise this very important point for lawyers. We have a colleague who was arrested, detained, and is in detention since the 14th of April. His name is Hijaz Hizbullah. There's been several media reports, statements issued. Now, his arrest, his detention raises fundamental questions in terms of the laws that are there to arrest and detain, due process safeguards that's provided by the courts, and what's happening now. What we hear, and this is based on a fundamental rights application his family has filed, is that he has very limited access to counsel. His family is unable to see him without those who are detaining him being in the same space. That goes to the heart of meaningful access to counsel. Now, this is provided by law. It's provided by case law. And we have a colleague who for nearly 4 weeks has been in detention with those due process safeguards not being offered to him. And I think that's something that we as lawyers, all of us, this is not a political thing. This is not taking partisan positions. This is due process safeguard. So if a lawyer is treated this way, what is the rights, what are the safeguards offered to other individuals? And I think that's a very, very important point in terms of legal issues, and raises other aspects as well. But I realize my time is up and I'm happy to bring up other things. But those 3 points I think are very important. Thank you.
Thank you, Bhavani. And we can come back and follow up in the next round. Umiza, may I invite you to introduce yourself and to make your reflections, please. Thank you. And may I ask everyone to turn their microphones off, anyone who's not speaking, if you could turn your microphones off, please. Thank you.
Thank you, Priyanka, for the invitation to speak at this on this webinar. I think it's a really timely topic, and I was really interested in the way it was framed in terms of inequalities. So I think I just want to start there by saying that the impact of COVID-19 is not going to be experienced equally by all Sri Lankans. There are those who are living in small spaces. There are those who share limited spaces with several others. There are those who have no access to clean water. Those whose jobs involve coming into contact with infected persons. And those in confined spaces such as remand prisons, who are fearful of whether this means that if one person catches this infection, whether all of them will be at risk. And there are those of us amongst us who are also more susceptible to an aggravated attack by this virus due to either age or compromised immune systems, things like that. So there are different levels of fears and anxieties that people are experiencing across the world and also in Sri Lanka. The measures in response to COVID-19 are also not going to impact people equally. We have, because this need to reduce transmission will mean that some parts of the population will experience the lockdowns very differently. Some individuals will experience the lockdown very differently from others. I'm using the word lockdown. I am also trying to understand how the curfew works at this time. And I'm grateful that Bhavani addressed that question earlier. Staying at home means, we must understand, means a shift of burden of housework to sometimes mostly women, right? They're taking on that work at this time. Being at home also means that sometimes you're trapped in a space with the person who's also causing violence or inflicting violence on you. So domestic violence is also a real issue. Not having access to a wage if you're forced to stay at home, or an income. To some, it also means not having access to food, water, other necessities because everything has gone online. To be confined to the home and to have no savings also means there are heightened levels of desperation, mental distress, and questions of survival that people are facing. I think when we talk about democracy and we talk about law and order today, these are the things, these are the issues that democracy needs to be confronting and dealing and addressing. When we talk about law and order and the justice system, we need to be looking to these institutions and the individuals within them to be looking for answers during these very chaotic and scary times for those people who are affected the most, right? So the inequalities are a given. We need to, anyone in public service knows about these inequalities, so we cannot afford to turn a blind eye to them. The law in itself is a neutral tool. It can be wielded to address inequality, or by pretending that inequality does not exist, it can aggravate the consequences for those who experience inequality. So I was thinking that I would talk about a couple of things. And I knew that maybe the subject of arrest curfews may get spoken about, so I might look at something else in terms of access to the law. And I want to say that there is some continuity when we talk about access to the law, because we experienced a lack of it, or I think there is much to be done in terms of improving access to the law, even prior to COVID-19, right? And what does it mean when we say access to the law? It means that we need, as a justice system and as a law and order system, we need to be meeting the expectations of people adequately. And I think we did have a lot to improve in that area. And now in this context, it means even more. It means communicating law well. It means police regulations, circulars from the Ministry of Health have to come out in Sinhala and Tamil simultaneously, because people can't be running around looking for what this means, asking people, where is the Tamil version of this gazette? Communicating the law improves certainty. And I think that is something that we really need to establish during this time, because communication also builds trust between people and those who are providing services. Improving transparency, again, I know Bhavani touched on it. It's a big area for the justice system and the law and order system. For example, judgments, orders just need to be easily and quickly accessible. It can't be a system where you take a lot of time and you push a lot of paper before you get a copy of your own judgment or your own order. But it should be publicly available to also ensure that all all of the law is known and there is some cohesiveness to what the law is. Because I'm sure in the current status, even prior to COVID, an order in a district court in Gampaha can be very different to an order in a district court in Mullaitivu. And we don't know. So as far as I'm concerned, we need to address the issue of the law can be anything across the country at this point. So just bringing in that cohesiveness, and then that cohesiveness in also jurisprudence is important for people during this time. And I think the system is not proactive. And I look at two issues to demonstrate that, and two issues that are close to my heart as well. One is the issue of domestic violence, and the other is maintenance. But in talking about proactiveness, let me also say that we don't have that rigorous legal aid program that ensures that everyone who goes into remand has access to a lawyer from the get-go. I mean, having legal representation is a basic right. There are many who are languishing in remand prison. For instance, it took COVID-19 to draw attention to the overcrowding concern. So roughly we have about 26,000 people in a system that can only accommodate about 11,000. And even within that space is so differently organized that in some spaces it's far more crowded than others. So it's an important move on the part of government to release it, and they did that. They had a task force that worked together. I think civil society also made some submissions, and they did release remandees from these confined spaces, also releasing them from that risk, which was a good move. But it was also something that was a risk because we had not addressed laws delays and we had not addressed overcrowding in prisons. On the question of domestic violence, at the moment in Sri Lanka, how we respond to it is by way of two agencies. The police go when you have a 119 call, and courts for protection orders. Courts have not been functioning for since these curfews came into effect, and only as the first speaker said, in this Monday the Supreme Court started functioning. And I know that courts in other parts of the countries have opened up, but they have postponed all the hearings and given dates for postponement, and understandably so. But when we look at what was available during this time, it was mainly the police as functionary for responding to domestic violence. To this date, I'm yet to come across guidelines or procedures that the police adopt when confronted with a case of domestic violence. So what is the standard procedure? How do you respond? Who do you interview when you go to the scene? How do you assess the level of threat and whether violence is likely to happen again? Who do you remove from the site of violence? Is it the victim? Because if the victim is removed to a safe space, is it not the victim who is being penalized because she, and mostly it is a she in these instances, is removed from a place that she is familiar with? There were also fears at that time where women thought if they called the police and they were the ones removed, they might go into a detention center because there is no certainty about what happens. How will the victim be supported if the person inflicting violence is the financial provider? So many women or victims, children, may not call in if they feel like the consequence is that the person who's providing for them will be taken away by the police. And what was the state response? How do we respond as a country to these issues? Do we set up a fund to ensure that those who are victimized, who have faced violence, can survive these few months? Those measures didn't come into play. Another issue was counseling, and that was also there before COVID-19 struck. Are we in a position as a country to provide long-term counseling that victims can assess? And when I say counseling, I'm not talking about immediately going into couples counseling, resolving the matter. once you meet a situation of violence, I think the first thing to understand is that both parties require separate individual counseling for the victim to reduce their levels of anxiety, and for the perpetrator, if necessary, to deal with that kind of anger management if there are those kinds of issues. So we didn't have these things in place at the time this crisis struck for measures to be changed, innovated on, guidelines to be introduced for the crisis. So for example, in other countries, in response to COVID-19, on the issue of domestic violence, they introduced emergency protection orders, quite apart from the orders of going into court, and you were able to get, in some instances, within 24 hours, you had access to a judge who was available. There was also some measures taken to make domestic violence support service providers as a part of the essential services. And some other countries, I think in Europe, gave express permission for victims of domestic violence to travel during lockdowns to seek assistance. So those were the kinds of measures that are examples, and we should have looked at our own context and tried to think of what we could have done in terms of a law that reaches out to people. And I think we really sometimes lack the imagination of reaching out, as law as something that reaches out to victims. In terms of maintenance, I think litigants who have filed maintenance cases previously had completely got cut off from financial their financial support. To date, magistrates' courts are not processing or taking up maintenance cases, is my understanding from other colleagues in other parts of the country. And this is of serious concern. To my mind, immediately what comes is that there can be two types of victims. One is that the person who is supposed to be paying the maintenance refuses to pay maintenance, although he or she has the financial capacity to do so, making this an excuse, making this crisis an excuse. And the other is where the person who provides the maintenance is a daily wage earner or someone whose income has been compromised and cannot then make the maintenance payments. So then how as a country do we then respond to this situation where people's survival, those who survive on that maintenance for themselves and their children, have access to financial assistance during this time? And these are the kinds of welfare mechanisms that, in terms of even new laws, I think we really should be looking at. COVID-specific laws, I'm saying, because I think a crisis requires laws for the crisis also. And hopefully they do it in a way that it is democratic, that it reaches out to people in such a way that it lasts into the future. The second thing that I'll touch upon, and I think I might have a minute, do I? Or have I gone over time? I can take it later on.
I think we're slightly over, but if it's a minute, please continue, or if you'd like to use the time after, whichever works for you. Thank you.
Okay, I'll just set it up so that I remind myself. So the second thing that I wanted to talk about was dissent as a part of governance. And again, I think Bhavani touched on this, but it's when I talk about dissent, really I wanted to say that it's these people who are in trouble, the daily wage earners, the domestic workers, the plantation workers, all of them, when they raise their concerns, the only space they have is the space of dissent. And that's a very varied space, and we can talk about that later on. Thank you very much.
Thank you, Meza. We can come back to that because it'll be interesting to develop that. Salia, may I invite you to introduce yourself and share your reflections with us?
Thank you, Bendu, and thank you for this opportunity of sharing views. And I'm Salia Piris. I'm a lawyer. I have been also a member of the Human Rights Commission in the past. But I think one main point which I wish to highlight here is that how during the epidemic, I think the legal system, especially the court system, came to a standstill. So I think this is one of our failures, and it is something which we have to see what we can develop on, because if we do have another lockdown in the future, this is something which has to be addressed. So from the 16th of March onwards, apart from the magistrates' courts hearing where people were produced and dealing with bail, almost the entire court system came to a standstill. The two apex courts have not worked except for maybe 1 day or 2 days in the Court of Appeal. The apex courts have not sat. Now, I think this is an indictment on our system, because I compare this to countries like India, the United States. The United States, for instance, the Supreme Court sat and is hearing cases by teleconferencing. In India, Indian courts used various technology, and this technology is not rocket science. These technologies are available, and what is required is for the system to be innovative. And unfortunately, I don't think we made that. We were able to reach that bar. So in this context, I think it's very important when we are fighting COVID. Fighting the pandemic is important, but it is also important to ensure that it is done within a framework of the rule of law and the protection of the rights of people. And certainly economic challenges have to be addressed, but also to be addressed in a way looking at the long term and with a degree of oversight or financial oversight which is required. So in effect, and this is so in effect for the last 2 months, we had only the executive arm of the government functioning, but not because Parliament was dissolved, but also the judicial arm, or also the apex courts were not functioning. So I think this was a drawback, and we have recognized that. And for one moment, we cannot blame the executive arm for the fact of the judiciary not sitting. It is just that we were not prepared. We were not prepared, and we did not respond quickly to what had happened. So we were happy from the 16th of March up to the 11th of May for our courts, for the courts not to function. Now, the drawback in this is many executive acts were performed without oversight. So I wish to highlight, Bhavani highlighted, and also Misa, on one issue which we saw was how people who dissented or who criticized were arrested by the police and produced before court. So some were given bail, some were remanded, some were sent to quarantine, were remanded but sent to quarantine for 2 weeks. And in that way, you had people who had expressed dissent being taken. Some of the perhaps not to say that every post on social media can be tolerated. There are certain comments which might alarm the public, and which should get caught up within the provisions of the law. But one must distinguish that from genuine criticism. Now, for instance, there was I read in the papers about a person who had been arrested for criticizing a divisional secretary, and he had been granted police bail. Now, in this sort of dissent, if people who dissent are arrested, then there must be oversight. So if the apex courts, if the Supreme Court was functioning, you would have found people going in before the Supreme Court, invoking the jurisdiction of the Supreme Court in a fundamental rights application. So the fact that the court system did not operate, I think, is a drawback. We must look inward, lawyers, judges, of how we can develop a system where the court can operate online. And also, so there were people who were saying, well, there was a pandemic. There was the Halstorf, was the Kesselwatta police area was the epicenter of the epidemic at a particular point. That is true, but the court need not have sat in Halstorf. There is a provision in the Constitution where the Chief Justice can decide where the Supreme Court should meet. The Supreme Court can meet at the BMICH. So I think this calls for, this is not in any way to find fault, but to see how we can change in the future, and how our system will be forced to address these issues. So that is one point which I wish to raise. The other which I think is important to point out is that there have been many issues where it would have been great if there was greater clarity. So curfew is one such thing. Now we have an order from a magistrate in Gampaha, from the honorable magistrate, who says that the curfew is valid. Of course, there could be different views, since the orders of a magistrate are not necessarily binding. But having said that, all what I want to say is there is the lack of clarity, and it would have been there could have been greater clarity if we could have looked at some of the legal provisions. So, for instance, if I understand the executive may not have wanted to use the public security ordinance, but then perhaps some extra regulation, which is under the infectious diseases ordinance or under the perhaps the Disaster Management Act, could have been used to clarify the situation. So, for instance, there is a debate which is going on at the moment about vehicles being taken in for violating the so-called curfew. Now, what is the legal basis for that? Can vehicles be seized? Can vehicles be confiscated? So these are issues. I think if there is clarity, it would be great. Of course, we all understand that this is an emergency, unprecedented. So one cannot expect either the executive or the executive arm to have everything in perfect order. There will be mistakes happening. There will be omissions. And this is not in no way am I saying this to undermine the achievements which have been done in controlling this pandemic. But I think when we are looking to the future, how can we ensure that the rule of law is preserved while fighting the pandemic? So, for instance, I was thinking one way in which the Disaster Management Act could have been used. In fact, the Disaster Management Act specifically provides for one of the natural disasters mentioned is an epidemic. And then the president can declare a state of national disaster, and then a whole lot of provisions kick in. So in this instance, of course, the executive chose not to take that, but a proclamation under the Disaster Management Act will be sent to Parliament, but it doesn't necessarily reconvene a dissolved Parliament. So it could be even the Parliament which is meeting after the general election, which could approve that proclamation. But I think it is ideal where there are existing legal provisions that the executive uses those provisions. And this is where I think it is good to look at these provisions. I need to point out that shall we say the way in which some of the laws were used in respect of even dissent, I think there is much left wanting. We know that the Human Rights Commission had written to the Inspector General of Police, especially because now, for instance, you found a journalist who put in a post disavowing racism was taken in under the ICCPR Act and was remanded. But there were others who were spewing hate, targeting specific communities, on media, but they have not been touched. So again, I think we also need to look at guidelines relating to, in this sort of situation, about the media, about how, and also not only the media, but also those who accompany the media, the government officials who are then accompanied by the media. So we found that actually there were things which were counterproductive. For instance, when people were in quarantine, their houses were shown. Their houses were shown. The locations were shown. Certain communities were identified. So how do we bring in guidelines to regulate that sort of conduct? These are things I think COVID. These are issues which COVID has raised. So these are some of the matters which I thought, but one more issue I think I must raise, that is on the issue of the burial and cremation. Once again, if there is a scientific basis which says that only cremation is done, that should be it. I think all decisions must be based on science. But when I looked at it, I had some concerns because I saw how the guideline on a particular day overnight was taken off and replaced with another guideline. Now, this is something, it may have been absolutely bona fide. And in fact, when you talk to certain medical officers, because this coronavirus is so new and it's uncertain as to how what its effects are, naturally, there are certain people who might even doubt the WHO guidelines. But what is important is, I think, to make people feel that they have been consulted, that their views, their ideas are respected. Because then you don't leave a segment of the population being hurt. So in this context, I think one approach perhaps for the executive to take would be to have greater clarity with people or with the public. So for instance, I was watching the Prime Minister of Singapore. He addressed the nation on several occasions, and he took the people along. He said, these are the things I'm doing. If this fails, this is what is done. And when he spoke in English, there were, or when he spoke in Malay, there were Tamil subtitles going on. So in that sense, I think it's very important for there to be respect to all the communities, because we are in this fight against this pandemic together. And I think where all political forces are concerned, there is also this, I think, that we must see how we can take this crisis as a moment of unifying our people, not where you're not using it to separate people once more. And so this is where I think the law and also the courts of justice have a role. And it is my belief that there have been where our legal system is concerned, we were not prepared for this. So as Amisa pointed out, even in respect of domestic violence orders or in respect of maintenance, there have been issues. So even, for instance, there may have been urgent matters arising in the civil courts. For instance, an injunction which was required, which could not be taken because the courts were closed. So I just want to finish with this. In contrast, you have all heard, Priyanka, I'm sure you've heard of this case in the Kerala High Court, where a man went and challenged a curfew on the basis that he wanted to go out and get cat food. And the court said, yes, it is an essential service. And court made an order that issued writ saying that he must be given a curfew pass. And in that, the court ended with observing that the doors of the courts of law must be open even at the times of pandemic. I think that is a lesson for our legal system.
Thank you very much, Salia. There's some great material there, but I'm going to first ask each of you to follow on or reflect on something that you may want to, and then I might see if we have some limited time to kind of share some of the themes that have emerged from your discussions and put that back to you. But perhaps, Ali, we can start with you. That's all right.
Yeah, as you correctly pointed out, there are some diverse views that have been expressed. A lot we can take from this, and of course we all understand that a lot of people have been unprepared for it. But that's not an excuse. Even if you are unprepared, you can still immediately innovate and come out with solutions. So when it comes to this, democracy should consist of all three pillars. There is no argument about it, and we are a country which is based on rule of law. But then the current situation is unique once again, unfortunately. If you look at judiciary, and nobody had prevented them from doing anything, that they are chosen not to innovate. That's a problem with it. And then Parliament had been dissolved. Parliament have been dissolved, one can see in different things. I'm not going to touch on the validity of the dissolution or anything, because probably we'll be arguing next week in the Supreme Court. That's sub judice for me, at least for me. Or otherwise, tactfully, I don't want to come out with my whatever the points which I may have. But subject to that, one thing is for clear, that President, to be fair by him, even on his campaign and the day he won also, he told the first available opportunity, I will dissolve the Parliament, I'll go for an election. So that's how it has been gone. So accordingly, it is a unique situation. It's not that executive is trying to suppress any of the other arms. It just it's going on. Having said so, I agree an ideal situation that all three arms should be there. When it comes to the important other part of it is I for one, is not a great admirer of this emergency regulations. We all have suffered through this emergency regulations, 83 to 88 to 89, and even before under Mrs. Bandaranaike. So if there is any possibility that emergency regulations are not brought in, I would always go with that because that will have several other challenges. And we all know whether under any government and any part of the world, there is this abuse of power take place from different level, and that could happen. And that doesn't mean that in the top they know about it. Sometimes people use it. I know last year post 21/4, there were about 2,200 indiscriminate arrests. Other than 150 which have been still detained, 170, all the others were taken for no, I mean, the absolutely simple posts of say in the I remember somebody was taken in for wearing a dharma chakra or something which is not a dharma chakra, and sometime ago, and somebody else was taken in for just saying in Quran, in his Facebook, Quran is the first constitution in the world. I mean, that's his opinion. So that's all were taken in and detained for so long. And it was a process, one by one, clearing them. And I was personally involved in them, helping the people who were who were involved in the process of extremism. So therefore, these are challenges. We are still, unfortunately, these challenges have been there for the last 70 years or so. One by one, we have to find a way to get out of it. Then, of course, this overcrowding of the prison is a great concern. I think that have been, I remember when the president visited the place, he saw that firsthand, and he actually had taken steps to come out with a massive prison complex in Homagama or some area, which will probably ease the situation, but it's not going to again eradicate the situation. But it's a good, at least first step towards that. Then, of course, we all know domestic violence. I saw in states domestic violence cases, so hotline, about 70% increase. Even in UK, that's the case. This is a massive problem. We need to find a way out of that also. So these are good situations. But again, I thought, though, even the things like maintenance, though it could not have addressed all the cases, but a great majority of or at least 50% of the cases, had the cases have been called and given a bank account. Now everyone has a bank account, and say that this has to be transferred from this account to the other account to a maintenance. It could have been addressed to a greater extent. So that, of course, need proactive interference from everybody on the line. So there cannot be any argument that freedom of expression should be preserved. That has to be guarded. It cannot be subjected to any undue pressures. But if you need something to maintain the law and order, you must use it. So as far as this quarantine law is concerned, good that Salia mentioned, I also went through that order in the magistrate court. I think police is of the opinion that quarantine ordinance is good enough for them to come out with this, and the Director General of Health is given the power to impose this kind of restriction. And further, police is also the opinion that powers which is vested with the Director General of Health could be delegated to the police, and the police is or to the IGP, and IGP is acting in terms of that. That seems to be the thinking of the magistrate in Gampaha matter. And one other concern which we all had it from the beginning is whether this kind of a situation would invite the public security ordinance, whether that falls within the public security ordinance. This is a situation. So that's how I think, I'm sure they would have taken all these things into their consideration and consulted the Honorable Attorney General and come out with it. Of course, one can argue always there could have been better other options available. But having said so, I think we must find a way to harmoniously interpret the constitution, and to get this rule of law is being strengthened. This is a struggle which is you are not going to attain in one day or two, but how do you work towards that? So then in that, this kind of discussion, this kind of suggestions could really strengthen the process. And we can also study from the other parts of the world. I saw Singapore had come out covering this, some of these areas and all those things. I also saw UK came out with a law with that. So we can go through study those things and probably introduce some of those laws which necessary, because I'm sure, unfortunately rather, this will be there for some time to come, and then we need to live with it. We need to live with it, and we can't be, you know, for example, I could see there is a sense of fear amongst the lawyers and the judicial officers and all those things, even to touch certain things. But had that the kind of approach had been shared by the frontline workers and the police and the healthcare authorities and the public, the health authorities, where would have been now? So no, we can't do that. We have to live with it, and these are challenges. We need to take the best of precautions and meet the situation. So I think this is time for leaders to emerge. You know, there are so many inventions have come out in different levels. School children are inventing things, and everyone is. I don't know, domestics are transferring their funds into their NOKs in their accounts. All these things are happening. I saw in India, the mango farmers are auctioning online. So even in Sri Lanka, I saw some of them auctioning vegetables online. So that's I see this. I'm glad that none of us try to make it a political thing and try to hurl accusation with each other and all those things. That's not our thing. You know, there is different thinking. Everybody has it, but how to work on this, improve the status quo, and go towards that near perfection. Perfection may not be attainable on the short term, at least. So let's work on that. Thank you for this wonderful discussion and the topics which we discussed.
Thank you, Ali. Thank you for that survey, and also for emphasizing the fidelity to rule of law and how every country has its own challenges in trying to maintain and reach it and practice it. Bhavani, over to you, please.
Thanks, Priyanka, and thank you for my colleagues for raising a host of issues. And I think we need to also recognize that you have also been very ambitious in terms of expecting lawyers to keep to the time, and we've done that, I think, so far, so well done. Look, I think a couple of things, and one issue I want to clarify in case there's confusion. I'm not saying emergency regulations are a great thing. Not at all. We've gone to court challenging emergency regulations, even as recently as last year. My point is, if one is to impose restrictions, there are laws that can be used to impose these restrictions. That one cannot be ad hoc about how you restrict civil liberties and freedoms. So I'm not saying the present laws, all of them are perfect. I think we'll all agree there has to be law reform, but that law reform also has to be based in that process that's provided by the Constitution. So you cannot introduce laws when there's no parliament sitting. So in terms of that situation, then we have to look at what is there at the moment that can be used, at least to provide clarity and certainty, and to at least prevent some form of abuse. So just want to be clear, I'm not a proponent of emergency regulations, but in the absence of information clarity, then what do you look at? But I think there's a basic issue we all agree here, is that there has to be, in terms of a crisis, in terms of a pandemic, one has to recognize there are rights, and there has to be dignity in terms of how people are treated. And in a situation where it's extremely uncertain, we do not even know that what would be the status tomorrow, that we need to keep these fundamental ideas in mind in terms of our own responses. As lawyers, we need to keep that in mind. So in that, I think that's why I go back to this whole point of there has to be information, and I think this was raised by several in terms of how are things being done. Communication, language. I think either Amis or Sali raised this language. If people don't understand how restrictions are imposed, there is a fundamental problem here. If you only communicate in singular, which I think all of us understand, but you're leaving aside a significant population, that is a problem. How are you then expecting people to follow what is supposed the law when they don't know what is being communicated? So communication, language, and being creative, you know, if we are to have systems working, these systems also have to adjust, innovate, as many have spoken. And, you know, looking at the new laws that have come about in the UK, in Malaysia, in Singapore, there is a recognition that you don't physically have to go to places, that you don't need to go physically to a courthouse. You can do certain things online. But that said, I think we also need to recognize the whole structural inequalities that Hermes was talking about. How many people would have access to a computer or online facilities, you know? So I think in Sri Lanka, when we talk about looking at other contexts, we also need to recognize how many people have access to certain basic things that we take for granted. So those things I think are very important in terms of our own legal responses, legal strategies. We could have the legal debates, but these are basic things. And I mean, while we recognize certain things have been done and certain things have benefited, I sadly see some worrying trends. And these are things I think are very important in terms of recognizing that this is a diverse country. So when you have communities that may be targeted because of racism, because of racial divisions, so there could be racial profiling. If gender is a factor, if economic status is a factor, we have, some of us have spoken to it. These are problems that need to be recognized. And finally, I know, Priyanka, before you start sending a message saying time is up, finally, the basis of our democracy. If we don't have accountability, if we don't have transparency, if we don't have oversight, now some things are working, like now we've got the Supreme Court back working. If we don't have those basic structures, basic norms that we take for granted, there is a worry. Are we then going into a point where there is authoritarianism? There's erosion of the rule of law. I'm seeing worrying trends of militarization. I'm seeing worrying trends of securitization. Are these issues that we need to then grapple with, possibly in the coming weeks or months, but these are trends that we need to recognize. So in terms of our response, while we have laws, we need new laws. I think when we talk about quarantine and prevention diseases ordinance, let's also recognize that's from the 1897. That's over a century old. So we also need to, when we talk about access innovation, think about what laws are best to respond to the present context, but keeping in mind basic norms like rights, dignity, accountability, transparency, and the rule of law. Thank you.
Thank you very much, Bhavani. That's very helpful to understand from macro ideas and values in a system down to how that plays out at an everyday level. Thank you very much for that. Amisa, over to you.
Thank you. So I think taking from what the other speakers have touched on as well, and going back to what I ended on, just looking at why dissent is such an important feature of a democracy. And I know we all have agreed that democracy, this is a democracy, and that we have all agreed that rule of law is important. But sometimes what it means is important to understand, because that's how it plays out. And when we talk about dissent, we're talking about the state accepting pluralism and accepting that there are different individuals and sections of the public with different opinions and ideas, and most importantly, different experiences. It demonstrates an appreciation of that diversity. And in order to foster it or to protect that right to dissent, You need to foster tolerance and broad-mindedness. That's the approach in which the state should meet people, with tolerance and broad-mindedness. And I think it speaks to a very fundamental thing, that those in power are not always right. They need to listen to people and understand problems. It's not a bad thing to be wrong, particularly when you're representing people. So the relationship between dissent and inequality for me is a fairly straightforward one. Those who are not receiving relief, those who are at risk, those who need greater attention and protection from the state must have a space to raise these concerns, their needs, their problems. And sometimes the only space that they have is the space of dissent. Because inequality also ensures that those who are privileged, those who are rich, have access to forums, people, and the ear of policymakers. Their concerns are going to get heard regardless. Controlling dissent has been a problem Sri Lanka has had prior to COVID-19 hitting. And I think this is an important thing to remember, that most of these problems predate COVID-19, and we are weaker as a country in facing this crisis and going forward. So for example, I looked at this, a colleague of mine sent me this judgment, I mean, it's well-known, Ekanaka versus AG, that spoke about dissent. And it says, and I'll quote, "The Constitution demands the protection of the right to think as you will and speak as you think, and subject to certain limitations, the expression of views which may be unpopular, obnoxious, distasteful, or wrong, is nevertheless within the ambit of freedom of speech and expression, provided, of course, there is no advocacy of or incitement to violence and other legal conduct." So it's interesting, even if your views are wrong, unpopular, obnoxious, that's the definition that we aspire to in this country. That is what we thought. We have moved so far away. And I think Bhavani and Sali Piris also spoke to the fact that we have misused the ICCPR. We have misapplied it. We have misused the Prevention of Terrorism Act. We have sought to control non-governmental organizations in the past. So we have adopted a more governance by fear approach as opposed to a governance by communication and governance by service approach. So this brings me to the question of security and the amount of security legislation that has developed in this country. When we talk about security legislation, and we spoke about the PSO and we spoke about curfews, and looking at also new security legislation, because that was a conversation not too long ago.
Hi, Amiza, sorry, can I just interrupt?
Those are the kinds of laws that give you very little information. They basically tell you, we know what's best for you. We know something, we know the reason for your arrest, but we won't tell you what it is exactly. It's a law that disadvantages people who get caught up in its clutches. So we must be very, very suspicious of these laws. And militarization then becomes also an added problem, because it adds to that layer of fear that people feel and are unable to then express themselves, express their anxieties, express their problems freely. And I think I would like to end on the fact that online is not always the answer. And I know Bhavani mentioned it, but not everyone has access to online. So when we do praise and push towards online solutions, public trust is also developing offline solutions for people who can't get online. We are not going to all get online anytime soon. So if it's building public trust, and this is a moment to build that public trust, I would say there are huge disparities in experiencing law and order in Sri Lanka. Some have experienced it in a very different way, where some people can go to court and ask not to be arrested, where others are, arrest after arrest follows them. So we need to understand that we come from a place of great inequality, and there's a lot to do in terms of earning public trust. And it's not always online solutions that will get us there. Thank you for the opportunity, Priyanka.
Amiza, thank you very much. I think it was great to bring out the idea that COVID-19 measures do not impact equally, and in fact, quite the contrary, and to illustrate with that some examples around significant issues on domestic violence. And thank you also for highlighting that, yes, the online world is not the only one, and we should always be very mindful of that. I think you have the quote of the session, which is, "Those in power are not always right." So well done. Now I'm going to invite Salia to provide us with some of his concluding thoughts. Hi, Salia. I think your mic is still on mute.
I think in the next few weeks and months, we will have to look at laws, and I think we should have a COVID regulation or COVID act. One person in the legal field who was talking to me, he said, if not for the quarantine regulations introduced by the British, that we would have been in a real fix during this pandemic. So we have to, I think, look at the regulations and have a new set of COVID regulations. But at the same time, I think it is necessary that those regulations also be looked at from a rights angle. When I say rights angle, not necessarily not only civil and political rights, but also economic and social rights, because we talk of social distancing. But for many people, even in Colombo, social distancing is a luxury. If you look at what is called the Watu in Colombo, social distancing is simply impossible. So how do you cater to those people? And so similarly, prisons, social distancing is not possible. Now, we saw at one point the Attorney General wanted the courts, he said the courts should not sit because of the COVID. But the fact is, if the courts did not sit, the certain prisoners would have had to stay another 2-3 weeks inside. And social distancing is not possible there. Finally, I would like to say that in all this, sometimes during times of crisis, people tend to look at the state, and people naturally give a large allowance to the state in terms of rights, so on, at least until they are affected. But we have to keep in mind that whatever in the fight against the COVID, that we have to safeguard the rights of people. And the civil and political rights are also important dimension, especially the freedom of expression, the freedom to discuss, to dissent, also the freedom to express the truth. We know that in Wuhan, the doctor who was a whistleblower, who ultimately died of COVID, the Supreme Court of China finally observed, they said people should have relied on the rumors. If they relied on rumors, things would have been better. So this is where the freedom of expression is so very important. And finally, I would like to say, in all these things, I think it is ideal that there must be civilian oversight of everything. The health sector, the fight against COVID, my view is that ultimately it must be led by civilians. Thank you.
Thank you very much, Salia. I thought that was very helpful to illustrate taking the judicial branch as an example of where things worked well or didn't work well, and also what the solutions might be should we find ourselves in a similar situation. Thank you for reminding us also of the steps that our independent institutions played, the Human Rights Commission, for instance, and also exploring some of the very sensitive issues we've seen reported in recent times around burial processes, and also foreshadowing the need for contemporary laws that are respectful of the range of rights which are protected under our constitution and which Sri Lanka is internationally signatory to. Firstly, I'd like to thank all four of you, Ali Sabri, Bhavani Fonseca, Amiza Tego, Salia Piris, for taking this time out and reflecting. And I know these are evolving thoughts and everything changes so quickly. What I liked in the thing that united all of you was, and possibly everybody who comments on this, is the unprecedented nature and scale of things. And also this idea that our system, and quite frankly, every system, every country's system, governance system, requires the various parts to work together. And each country may be in unique situations due to constitutional or other arrangements, but that idea that the default setting is that those parts work well together. Thank you also for respecting the idea that we don't enter into the space of matters that are before the Supreme Court, namely the circumstances of Sri Lanka's parliament and what might happen in relation to that. These thoughts that you've shared with us, one day we hope to put them together, come back to you, take them and share them with other stakeholders, and in due season, our new lawmakers and decision makers. On behalf of Westminster Foundation for Democracy, massive thank you all.
Thank you.
Thank you.